Okay, good evening, members. Welcome to this evening's meeting of the Standards Committee. Before opening the meeting, please can I ask any members or officers in physical attendance with an electronic device to mute it to avoid feedback. Please also, if you're joining remotely, can you avoid using your camera and keep your microphone switched off unless you wish to speak, and ideally not to use the camera facility at all, as this could affect the IT quality. This meeting may be recorded, and the data collected during the recording of this meeting will be retained in accordance with the Council's data retention policy. The recording of the meeting may be added to the Council's website. This evening we do have a number of people joining remotely. We also have the independent person in attendance, Patricia Richards, and the CALC representative, Councillor Jeff Tutt. Also in attendance we have the Chief Executive, Larissa Reid, the Monitoring Officer, Robin Harris, the Head of Housing and Community, Charlotte Hudson, Community Services Manager, Steph Curtis, and Democratic Services Representative, Joe Millard. There is not an evacuation planned for this evening, so if the alarm sounds, you will be directed safely out of the building into the car park. The lifts must not be used at that time, and please can I just check if there's anyone here in physical attendance that might require assistance during that. Okay. I will hand over to Joe Millard to let us know about any apologies for absence and substitutes.
Thank you, Chair. Apologies have been received from Councillor James Hunt, Mark Last, Pete Neal, Hannah Perkin. The substitute for Mark Last this evening is Councillor Angela Harrison, and for Councillor Perkin is Councillor Charles Gibson. Thank you. Thank
you very much, Joe. I will now ask members to approve the minutes of the meeting held on the 16th of April 2024, minute numbers 831 to 835. Agreed. And on the 15th of May 2024, minute numbers 37 to 38. Thank you very much, members. I will now just ask if there are any declarations of interest. Nope. Okay. We will now move on to item 5, which is the Code of Conduct arrangements. Hopefully members will have received one appendix by email, and I believe everybody will have received one of these as well, which has some further comments that were made by Councillor Hunt. Has everybody got a copy of those? Can I just check? Yep. Okay.
Sorry, Chair, could I just mention that I didn't get a copy until 5:15 this evening. I didn't have an opportunity to download it.
Yeah.
I do have a copy now.
Yes. No, and also in the further report was obviously only circulated a couple of days ago. I think because no.
A couple of days ago.
Yeah. No,
past 5 tonight.
Okay. All right. Appreciate that. We will take that forward, and that's noted, and hopefully we can avoid that happening in future. But also just to say that a lot of the feedback for this was obviously happening during the election period. So I understand that members might not have quite been able to give it the full attention they have, and I think today is obviously a further opportunity to discuss things further, and as that conversation develops we can decide what our next steps as a committee are on that. But just to kick this off, I will invite Robin to introduce the report, please.
Thank you very much, Chair. As I don't think it's necessary to labour the report itself particularly. I think the benefit is to be had is in going through the comments that have been made on the document. So I'll simply say that the report asks the committee to consider the comments made by members of the Standards Committee on the draft Code of Conduct complaints arrangements and determine what further consultation or steps should be taken with those draft arrangements. And if I may, Chair, without further ado, I'd like to go to the comments made and start with Councillor Hunt's comments, which are the ones which unfortunately have come forward late, which is very unfair on Councillor Hunt, because actually he delivered them to me in a very timely fashion. It's just an unfortunate administrative error. So in relation to Councillor Hunt's first comment in relation to paragraph 1.1. He says, shouldn't this just say these arrangements are made under section 28 of the Localism Act 2011? They set out the process that Swale Borough Council has adopted for dealing with complaints that an elected or co-opted member or parish town councillor has failed to comply with the Code of Conduct. There seems to be no need for co-opted to be there, which I think he means for the second time, on which I agree, and with members' consent I will just make that amendment. Thank you. His second comment is merely in relation to the general principle of having the interpretation at the beginning of the policy. I take it that we're all agreed on that. We wouldn't be seeking to move it. Thank you, members. Actually, I've got to find his next comment in the document, because the document's surprisingly hiding the comments. Here they are. So. His next comment is in relation to paragraph 3.2 and picks up on the mention of a substitute independent person. My comment on that, in actual fact, is that at Swale we have 2 independent persons. Even when we had 1 independent person, it's never been within my knowledge that we've used a substitute. And so on that basis, that I'm happy that we simply remove that with members' agreement, that there won't be a substitute independent person. We'll either use our own independent persons or we'll deal with that as and when it arises. Question from Councillor Tutt.
Yeah, thank you. I don't see why there shouldn't be substitutes. You could easily end up with no independent people here. So there should be a mechanism in place to allow a substitute.
Yeah, Robin. Yep.
So entirely understand the principle of that. I think that's part of the reason why some years ago we moved from having 1 independent persons to 2 independent persons. And obviously, if we were to lose one of our independent persons, then we would appoint another independent person. So we had 2 independent persons. So on the one side of things, I recognise the concern that you're raising, and obviously it's a matter for our members. That obviously they've heard your comment, and it's a perfectly sensible one. Would members like to retain the option of a substitute independent person or to redact it?
Yep. Is there anybody who wants to go? Yep.
A hugely strong view, but I'd err on the side of caution that having the option is not unhelpful.
Councillor Palmer.
I was going to say the same. A substitute could be one from another council, because both have been struck down with some unknown disease or something. And rather than wasting time trying to appoint someone, you could call in a substitute. Thank you.
So in actual fact, if I pick up, the sense in the room, in fact, is that we keep it. Was there something else you want to add, Councillor Tutt? Sorry, Chair.
Thank you, Robin. Does that also apply to myself as a calc representative?
So it doesn't in respect of the Code of Conduct arrangements, because you don't have a role to play in the Code of Conduct arrangements.
Whether I'm a substitute, whether I have a substitute.
It's not relevant to the thing that we're talking about now, because this is the specific Code of Conduct arrangements, and it's about the independent persons being substituted. So it doesn't cover your particular role, so that's not what we're addressing at the moment. Councillor Hunt's next comment, he states, and this is about paragraph 4.1, which I think might need to read a little bit just to understand it. A complaint alleging a breach of Code of Conduct by a subject member must be made either in writing, and goes on, via the council's website. And so it actually says using an online complaint form provided there. So I don't know whether that's misleading or not, because it is possible to access a PDF form online, but it's not a truly online form. I think there is a conversation for another day about whether or not we'd like to explore having a truly online form, but that's not where we're at this evening.
So can I just pause there, because I think Councillor Baldock would like to speak.
Thank you, Chair. It's on a separate matter, so it's on another issue about after Councillor Hunt's comments.
Okay, no problem. Thank you.
So returning to Councillor Hunt's comments, he says, this appears to assume that the complainant has read this document and will know how to complain. The general public may just email the council or another member or officer. Should there be a section to say that a complaint via other means will be referred to the monitoring officer, or that a complaint will be advised on how to will be advised on how to complain?
Councillor Palmer.
That's all well and good, but the the Localism Act is quite clear, and Section 28 does actually state that to trigger an investigation, an alleged breach of the council's must receive detail. The council must receive details of that allegation in writing. So there's no option to say we can put it in another matter. Writing could be email, an online form, or a letter. So I think there's got to be a clear indication. If someone writes in and says, I think I'd like to make a complaint, then I think the monitoring officer should go back and perhaps say, however, can you be more specific on what you want to complain about, and seek clarification?
Yeah, so, interesting. Sorry, you're happy for me to respond?
Yes,
Yeah.
please, yeah.
So, I completely agree with you, Councillor Palmer. As you say, as a matter of law, you have to receive a complaint in writing. So we can't, for example, on one side of things, insist that someone provides a complaint form, because if they have provided a complaint in writing, then they have met the legal requirement. However, I'd be inclined to say, as a matter of practice, when people complain to me, if they complain by way of an email or a comment, or in fact, some come through customer services, not uncommonly, that I generally will say, can you please complete our complaint form? And I also, as a general rule, ask them to specify the bits of the code of conduct they say that have been breached, because I find that helpful in relation to dealing with the complaint as it moves along. However, I think those are things which are aspirational, and we could sort of say we encourage people to do this and that sort of thing, but I think we can specify it, because if they make the complaint in writing, then they've met the test under the law.
Only if they make the complaint providing details. If it doesn't provide details, then it's not compliant with Section 28. That was Mike made clear in the Tonbridge Council and the Local Government Ombudsman, and that was at paragraph 56 of the Ombudsman's report.
Yep.
So the trigger date isn't necessarily when they write in and say, I want to have I think so-and-so's done something wrong. If the monitoring officer then goes back and says, can I have further details? The trigger date is when the details are supplied.
I think that's fair comment. Yes, like ultimately there has to be sufficient information in something in writing to take forward a complaint. Yeah. Just finding the next comment from Councillor Hunt. It's obviously quite a bit further down. Hold on. It's about the complaint form, I think.
It's about the equalities monitoring.
Oh, I think you're right. Yes, bear with me. I haven't got there in my document yet. Hold on. Sorry, members. I'm just getting there. It's scrolling down incredibly slowly. This is it. Yeah, here we go. So yes, Councillor Hunt is asking whether or not having equalities monitoring information on the form is necessary. This is a matter I don't particularly have a view on, and I'm happy to be guided by members as to what they would like. Equalities monitoring at the end of the complaints form.
Yes.
If people want to fill it, they fill it. If they want to fill it in,
Yeah.
they will fill it in. If they don't, they don't.
Just so, if I can just ask if members come through me if they've got anything to say. That's just for clarity. I think in this agenda pack, it was on page 24. It's the equalities monitoring form that is appended to the complaints form. So, did anyone have anything to say on that? Yep, Councillor Gibson.
Thank you, Chair. Just to clarify through Robin that they don't have to fill out that form to have completed the form. So if they've completed a complaint form with a sufficient amount of detail and they choose not to include that detail, it's still a valid complaint.
Correct.
Obviously, it could be helpful in the context of the complaint where person's orientation or gender or age might be relevant to that complaint. That could be helpful, but obviously if it's not mandatory, then I'm perfectly happy for it to remain. Thank you.
Just for clarification, that's obviously monitoring information, so it wouldn't actually have any bearing on the nature of the complaint itself, would it? So in that instance, yeah, that wouldn't necessarily have any application for that. Councillor Palmer?
It just might be helpful to put optional. completion of this is optional.
Completely agree with that.
Yeah,
Take all
that sounds
members are
sensible
happy.
to me. Were there any other comments? Yep, Councillor.
I think question 2 on the equalities monitoring information is quite limited with just 2 options. I'm not really sure partnership status. I'm not sure why we monitor that for this instance. And again, I think they're quite limited. Perhaps it could just be empty boxes and you can write in how how you describe yourself. Question 6, is mental health problems the right term? I don't like the term problem, but if that's correct if that's the common phrase used, I don't know. Is it a problem or is it a condition?
Yes, it does seem a bit clumsy.
I say, would members like to suggest an alternative form of words? I say, I don't want to get into dangerous territory here, but question 2 is in relation to sex, not gender. So,
yeah. Does the council currently have equalities monitoring for other aspects? I imagine we would do for example, if you apply for a job and those sorts of things. So can't we just look at using something similar and therefore we're consistent with our wording? Yeah.
I think so. The steer from members is that we will retain this because and be clear that it's optional, and we will look at the wording used and make sure that we're just using consistent wording across what other documents in the council use. Thank you. In actual fact, I've noticed we did inadvertently jump past one, which was that Councillor Hunt had done a comment in relation to the complaint form, said how a complaint's dealt with now. This form seems like a lot of work for someone wanting to make a complaint. Could the process or form be made simpler from initial complaint, then more details requested if taken further? Maybe that is the case, but it doesn't seem clear from this document. I think actually we've covered that in the debate we've had with Councillor Palmer in relation to actually the details, and when the details arrive are quite important, because that it does define when the complaint is received. And I think we've already agreed that actually across this group of members, we see the benefit of the people using the complaint form and as far as possible, because it gives consistency in the complaints. So if people have a different view, by all means, say so. Thank you.
Yep, please, Councillor Jays.
Yeah, I think if someone doesn't want to fill out 3 pages, then their complaint's probably quite trivial.
Just scrolling down to the next comment from Councillor Hunt. I think this is it. Yes, so Councillor Hunt observes that the procedure for investigating complaint Annex 2 is much clearer, much better than before. I think I'd comment that we didn't have one before, so yes, definitely, I agree with him. It's clearer and that we should keep it as it is unless there's any amendments suggested. Councillor Hunt's next comment in relation to paragraph 2.1 says the hearing panel consists of 3 voting elected members drawn from the Standards Committee, one of whom shall be elected as chairman, and his question is, should be elected by who? And the previous arrangement said that effectively the monitoring officer would select the chairman, and he would like to be clear under these circumstances who would be made the chairman of the panel now. My view on this is that these are the arrangements for members by members, and so I would be perfectly comfortable if the members of the subcommittee vote amongst themselves to determine who should be the chairman. That would be my suggestion, and that we could add a line to clarity if that's something which is accepted by this group.
Yep, Councillor Palmer.
But is it worth selecting the chairman by the hearing subcommittee before the hearing date? And then it's all done beforehand, and if there's anything that needs to be discussed with the chair, that can be taken up in the knowledge of who the chair is, rather than on the day. Thank you.
Just Councillor Harrison.
Thanks, Chair. On the only other hearing that I've ever done, which was licensing, the chairman of the panel is selected when you rock up. Usually, well, I don't want to do it. Can you? There's many of them. So, if that's the way it works on the other hearings that we operate as a council, then that should be. Otherwise, somebody's got to get those 3 together, or the email, and it could be a bit. I think it's creating work for the sake of it.
I think there is a point to be made in relation to if you needed the chairman to make a decision ahead of the panel. Pretty much that's what you're driving at. And I think there is a general catch-all in here, which is that. So I think the starting point is the members will elect the chairman and elect the chairman when they arrive, and I say there is a catch-all provision here that these can be amended where it would allow fairness to arise, because with the best will in the world, we write these things and we try and come up with something that works in every situation, and then, as the expression goes, no good plan survives contact with the enemy, and something comes along and you realise that your arrangements, even when they're very thorough, don't meet the circumstances in case, and in those circumstances then you could potentially, with the agreement of all parties, nominate a chairman between the members earlier and then have that person as the chairman. That would be a way around it.
Councillor Palmer? Yeah.
But and that's why it might be worth sorting out earlier, because at the standards hearing training they were quite clear that if a subject member of a complaint objects to a member of the panel, then that if there are valid grounds, and what you don't want is the panel being objected to on the day, you want it decided beforehand. So there may be another good reason for having it arranged prior.
Yep, Councillor Jays.
So on the three standards hearings we've had since I've been in post for 5 years, it's always been the chair or the vice chair that's chaired them. I wonder whether that should be almost a presumption in the constitution or in these hearing rules that it's likely to be the chair. One example, the vice chair chaired because the chair was one of the complainants.
Councillor Harrison.
Thank you. I get having the panel selected because, from my experience on licensing, sometimes it can take weeks for people to say, well, no, I can't do that, but I could do that, and you can't do that one, but I can do this one. So actually getting those three together, I would thought that common law would say, when you're writing to tell the individual about the hearing, you tell them who the three panel people are, which would be at least a week's notice, which would give you time to go through those other people that said they could do it. But in terms of the chair stroke vice chair of a hearing, it's never been the case that an individual can object, because they can object to people on the panel. But what happens if amongst yourselves you've said, well, I think I'll do it when we get there in a week's time, but I'm objected to a week in advance, so then somebody else is going to be it.
Yep, Robin.
You can be too helpful sometimes. I've done a number of hearings on disciplinaries, and so I relate that sort of information there. You could object till the cows come home.
If I may respond,
yes,
actually,
please.
Councillor, actually, I think between the two of you, actually, I don't think you're actually a million miles apart, because I think the concern you had was the ability to object to a panel member. So if we were to say that the selection of the panel happens in advance, but the selection of the chairman happens on the day, then obviously the subject member would have had the opportunity to object to any member of the panel, and therefore if they'd been successfully removed from the panel because the objection was upheld, then there wouldn't be the chairman. So, yep, yes, I think excellent. We can.
Was there anything further? Yeah, Councillor Palmer.
And Councillor Jay's point about, yes, it could be the chair of the Standards Committee and the Vice Chair, but I think if we're going to do that, we need to amend the Constitution to reflect that.
That's actually not what these arrangements suggest. And these arrangements would become under the Constitution. So I think there's only a couple more comments from Councillor Hunt, and then we can go back to the other comments. It's talking about paragraph 11.3c, which says, having taken into account the independent person, the subject member and the monitoring officer's representations on the application of sanctions, the hearing panel will reconvene the hearing in public and the chairman will announce, and then at C, the recommendations, if any, to be made to the borough or parish council or monitoring officer. And Councillor Hunt says this needs to be made clearer. Where it says made to the borough council, is this full council or a committee? In my view, this should be full council, just to be clear. In my view, it's within the gift of the panel, and that they might feel that it was appropriate to report that person to a particular committee where, for example, the mischief had occurred on a particular committee, and I think it's within the gift of the panel. So I wouldn't be minded to insist that it was the full council, but again, I'm happily guided by what members would like.
Is there any member feedback on that at all? Yep, Councillor James.
So I agree with what Robin said. If it happened on the planning committee, it might be appropriate to report back. So I think leave it as it is.
Thank you.
Any other comments? Yep, Councillor Gibson.
Thank you. It's just the repeated "or" reads quite awkwardly. So I'm just so the recommendations, if any, are reported to, I think, the borough or parish council, but surely not all monitoring officer. The monitoring officer surely has to happen in the sense that you have to be told. So that's not an either-or option, is it? That's that should sit slightly separately in the sentence. It just it's the English grates of it.
Yes. I think the chances of going to panel and the monitoring officer not being aware of it is pretty slim, isn't it? In reality, so I'm happy to remove that if members are minded that it's a superfluous bit of language.
I'm in favour of removing superfluous things. Thank you.
And Councillor Hunt's final comment in relation to paragraph 12.1, which is just the list of sanctions that are available. He says it's very helpful to have these listed, on which I entirely agree, and I would leave them in unless there's any other comment.
Yes, that's something that I was in agreement with. Councillor Harrison?
I don't know if it's appropriate, Chair, because obviously I wasn't going to be here for this. But ever since we were taken out of the local government commission thing for...
Standards Board for England. I think
That's the one. That's the one. And given these standards committees, we have, on the odd occasion, and I think it should be, and I have raised it intermittently over the past however many years since then, the sanctions available to the committee, to the hearing committee and all the rest of it, basically is a waste of space. And what we said when we had to set up these committees was, yeah, where's the teeth? And as I say, intermittently over the years, I have suggested that we write to the relevant minister and say, look, we need some teeth. If your peers feel that you've done something wrong and want to sanction you, but there's no teeth to do it, I would be saying, well, why am I here? Oh, look, here's my wrist. I'll miss a meeting. Yeah, great. What sanction is that? Now, I know from research that it took many, many moons for people up at the big house to actually start doing these sanctions. So I'm not expecting anything overnight. But I do think, and we're not alone here, the majority of councils in the country who were required to set up these standards committee have concerns that there is little to no teeth in the sanctions available to them. So my proposal would be, after each and every standards committee, as opposed to hearing, we do the lobbying. We write to the minister and say, yeah, by the way, we've written before, we're writing again, we won't give up because we think that we need to do something on this. Some of the issues that have come up in the past at this council since we've had standards committees are serious in terms of reputation and all the rest of it, and you just think, oh right, well, as long as I stand up here before you and I say, oh, I'm ever so sorry, people, that's okay. No, it isn't okay. What sort of sanction is that? So I would like to propose at the end of this that at the end of each and every standards committee that you have, you take the opportunity to write, the chairman writes to the relevant minister and requests that this is reviewed. The issue of sanctions or lack of them is reviewed. Thank you, Chair. I hope somebody from my group would second that.
Thanks, Councillor Harrison. Councillor Palmer?
I mean, I'm quite happy to second that in some respect, but I'm not sure if she says after every standards hearing, committee hearing. Committee.
No, committee.
Does she mean standard hearing committee? Because
this which meets 4 times a year.
okay, no,
Sorry,
that's
Chair.
fine.
This which meets 4 times a year.
Because I think if you're going to have firmer sanctions, and because of the Standards Board of England, you did have the right to appeal to a Tier 1 tribunal, whereas when you have a standards hearing, it does say there's no right to appeal. It doesn't mean that a council can't have an appeal system. And sometimes people may feel that being dragged through a standards is a reputational damage to their personal standing in the community. And that can have more harmful effect than being taken off of a committee for 6 months. And it may have an impact on their job, and it may have an impact on other things. So I think sometimes, as members, we have to really think carefully and say, it's not just a slap on the wrist. It's a process which should follow due process. And if it doesn't follow due process and is abused, it brings it into disrepute. And I'm afraid, from my experience of the standards process, this council has brought it into disrepute. Thank you.
Okay, thanks, Councillor Palmer. Obviously, yeah, well, we've only just... have we concluded all of Councillor Hunt's comments? Yep, there's nothing further to say on those.
Councillor Hunt's comments are finished, then we've got the rest of the comments on the document.
Okay, so there are further comments. Councillor Baldock, you'd said you wanted to say something separately from the feedback we were giving on Councillor Hunt's comments. There are still other comments from members on this. Do you wish to come in now or after that?
I wish to comment. There's other points I want to make.
Yep, that's fine. Go ahead. Yep.
Point about, I have been the victim of what even all opposition groups called a kangaroo court under the previous administration, which was a complete show trial. Had they have had serious sanctions, they would no doubt have used them. Now, you've got to remember that there are times when councils use the standards politically. That happened under the Conservative administration regarding the Blue Papers debacle. If you can take strong action against people and you're in a kangaroo court council, then there's nothing to stop them basically taking away your democratic rights and the democratic rights of the people who elected you. I think it's very easy to say, oh, we should have greater powers. The greatest powers belong to the electorate, who can say yay or nay. Once you give too many powers to a standards committee, as Richard said, without any right to appeal or any right to challenge it or take it outside of that council, you are open to quite political and severe abuse. So I think that unless there is a proper accessible means to challenge a standards hearing, then you need to be very careful what you ask for. Thank you, Chair.
Okay, just before I come to you, Councillor Harrison, Councillor Braun had indicated he wished to speak.
Yeah, I just wanted to say on Mike's point there that part of the lobbying could be for a better appeal process, but also the electorate don't really have that much power considering it's a 4-year fixed term. So it's extremely, I think, hard to say they have that power if somebody were to do something and then they wouldn't really face the consequences for another 3.5 years, let's say, because that's not until when the election is held.
Thank you, Councillor Harrison.
Thank you, Chair. Now, whilst I do like to, it would be nice to think that Swale Borough Council writes and lobbies and it happens overnight and Councillor Harrison has given her taser at long last. However, I do know that this is, I've been asked him for years, Charles, still waiting. I know that that's not the process, that's not how it happens. All I'm saying is that we, and let colleagues in the DCN and all the LGA and God knows what know that we're doing it. All I'm saying is that we should be writing to the Minister saying, can we have this reviewed? Now, it could, when you ask for a review, if they do it, to be fair, they will go out and consult the 652 councils or however many there is. And at the end of the day, if they decide that there should be proper sanctions for standards committees, the quid pro quo could be an appropriate appeals process. I don't know. I'm not prejudging. All I'm saying is let's get back on the bandwagon and ask for a review, and continue to ask for a review of this, along with our colleagues up and down the country, until they do it, because it does need reviewing. Thank you, Chair.
Thank you, Councillor Harrison. So, is the proposal that you're making that there's a review of the standards regime in local government, or is it in particular about the sanctions? Because obviously there's a...
I would say including sanctions. To my knowledge, could have had a bit of a gap up here, I don't know. We've never had a review. I mean, now and again, the LGA asks for comments and they feed it up there and, black hole, nothing. All I'm saying is that let's lobby for a review of the process and including sanctions.
Right, thank you. Robin, was there something you wanted to quickly come in with?
So if I may, Chair, we are getting a little bit off topic here, as I appreciate we were talking about the sanctions that were available under the existing regime, and we've moved on to what sanctions might be available under a different regime, and letters that we could send to the Minister. I don't know if anyone's noticed, but there has been a change of government. You may not have seen that, but the previous government was very clear that the reason why they abolished the Standards Boards for England and introduced the Localism Act was because they wanted standards done in an entirely different way, and they weren't going to have the sanctions that existed previously. Obviously that situation may change, but I'd respectfully request to members that actually we park that now and that we go back to the comments on the arrangements that we're trying to agree, because actually we've still got a lot of comments to get through, and I think, if we wanted to have that debate about, we could bring it onto a future agenda if members wanted to, and we have a debate about that, because we could spend the entire evening on it.
Yeah, thank you. We could, although Councillor Palmer had indicated, and I did acknowledge that, so I will let you have a comment if you want to, Councillor Palmer.
Right, and I think, yes, let's move on. But Robin's right, but Parliament did look at it, I believe it about 2 or 3 years ago, and they said there would be no change. And he's right, there is a change of government.
Okay, if we just then continue with the comments submitted by members.
Sorry, Chair, so my proposal, which Councillor Miller was happy to second, is not going to be looked at.
If we could complete this agenda item, I'm more than happy for you to take a proposal forward, which then the committee can vote on. But if we could just complete this and conclude this, that would be great. Thank you.
Thank you, Chair. So the first comment is on paragraph 2.3. And everyone has this in their papers now, so we've not got the slightly difficult situation with Councillor Hunt's stuff being brought in at the later stage. So there's the addition of the complainant must highlight the areas or how they feel the member has breached the code of conduct. My view on this is that we did briefly touch on this earlier, and it might be something that we want to bring into a different part of it, but this is the interpretation section and it's the definition of a complainant, so I wouldn't make that amendment here, whilst I would be happy to look at the sense of the amendment elsewhere in the document. If there's no other comment, then paragraph 2.6a, referring to the independent person whose views are sought and taken into account by the Borough Council before it makes its decision on an allegation that he has decided to investigate, and whose views may be sought by the Borough Council at any other stage. Addition, note the independent person's advice must not be sought until a written complaint is submitted as required by section 28 of the Localism Act. Again, I think potentially because this is in the interpretation of the independent person, I'm not sure that sits well in this section. I think how the independent person is used, it could be looked at elsewhere in the document. Again, there is a comment that says, can the standards hearing panel decide the date of a complaint? Again, obviously this is in the interpretation section of the document, so I think it might be a point made elsewhere as well. Perhaps it might be appropriate to pick it up elsewhere. If it isn't made elsewhere, I can deal with it now quite swiftly. Shall I deal with it now quite swiftly? Can the standards hearing panel decide the date of complaint? I'd say one of the purposes of a standards hearing panel is to determine the facts in issue. So therefore, if a date of a complaint is a fact in issue, then it is open to the panel to determine it. That is my view.
Yep, Councillor Palmer.
Not according to the local government ombudsman, because at the Tybridge Council report, at paragraph 62, it's quite clear that the monitoring officer is to decide the date of the review of a complaint, and that's quite clear under section 28. It's the monitoring officer's role to decide the date of a complaint, not a hearing panel. Thank you.
So, in relation to the arrangements, we're not having the Can the Hearing Standards Panel decide the date of a complaint in the interpretation section. So in relation to paragraph 2.7, investigating officer means the person appointed by the monitoring officer to undertake a formal investigation. This is a comment. In my view, the investigating officer should be external to the council from a pool of investigators approved by the council. In actual fact, that was a decision that the council took some time ago after a standards hearing, and there was a complaint whereby there was no further information that could be gathered in respect of the matter at hand, and so the investigation was completed by the monitoring officer in the agreement with the independent person. I've certainly had situations whereby a subject member has indicated that they would not like an external investigator to be appointed. So whilst I'd say it is normal practice for an investigating officer to be external, that is not always the case, and it depends on the facts of the matter. But ultimately, these are your arrangements, and so if members would like all investigators, regardless of the view of subject members, to be external investigators, and there to be an external investigator, then ultimately it is a matter for members.
Yes, Councillor Palmer.
I think because officers are extremely busy, that to put this burden onto officers would be perhaps affect other work of the council, and I feel that for a member to have a fresh pair of eyes, it would sit comfortable with them that they haven't been subject to, I believe someone used the expression, a kangaroo court. So I feel it's imperative that you have someone with a clean pair of untainted vision, no previous knowledge, who can investigate and give an impartial assessment of the situation. Thank you.
Councillor Gibson.
Thank you, Chair. I agree with Robin. I think it might be sensible to add to the end of the sentence as appropriate for the or as requested by the subject complainant or member, because I agree it's entirely possible that the right answer is both options can be the right answer. Clearly, there are situations, as Councillor Palmer describes, where an external investigator might be more sensible, but also opportunities when that would be a waste of our neighbours' resources as well as impractical. So I'm perfectly comfortable with the sentence as it is, if there's the possibility to add that as appropriate type language at the end. Thank you.
Councillor Palmer.
As appropriate to who? To the subject member? Or, there must be some way that either the subject member can say, hold on, I object to that officer looking at it. We've had many run-ins. I don't think they would be an unbiased or can come to it with a clean slate. So that's why I think when you use words like as appropriate, I'd have to ask who decides what's appropriate.
So your concern obviously is that the subject member has the opportunity to request an external investigator if they wish, is that?
Perhaps the right to request.
Yep. Is that something
if
that...
they're comfortable with an internal investigation, that's fine. But if they say, I feel it would be better externally,
yep.
then I think that's... And let's face it, I
so
know it may cost, but then freedom of expression and rights are quite expensive.
Can I just check, were there any other indications from members? Yep, Councillor Jays.
So I think it shouldn't be a blanket system of it's always goes external. If we take the case in November 2020 where the subject member admitted to it, what is the point of going external? He's over and done within 38 minutes, so I think it shouldn't be a blanket ban, but perhaps it should be an option. And I think the person that did our training, a former monitoring officer and legal officer of this council, would be an excellent external investigator.
Were there any other comments? No, Councillor Palmer.
Yeah, I mean, if someone's going to say, yes, I'll put my hands up to it, doesn't need investigating.
I think we've sort of come to a sort of conclusion of some option that the subject member can request an external investigator, but that is not the default obligation. Yeah.
I wonder if an amendment to the extent of as adding something to the line, as Councillor Gibson suggested, but slightly different, along the lines of the views of the subject member will be sought in respect of the investigator. Because.
But then, I've taken your views, but I've ignored them. Yeah. It's got to be the right of the subject member to say, hold on, I'd like an external investigator to look at this.
If that's members' view. I'm perfectly comfortable with it. There's 2 members saying yes.
Councillor Harrison.
Sorry, Chair. How much is this going to cost? We ain't swimming in money. We ain't got a money tree at the back garden. In fact, we've got nothing. I would support what Councillor Gibson said about or an external investigator, as appropriate, and I'd be quite happy that the monitoring officer, legal officer, actually look at it and said, well, actually, because these things are done all the time. Not just these things are done with staff. You know, it's normally an internal investigation, but sometimes I'm talking about disciplinaries. On occasion, it's well, actually, I think we need somebody from another authority, or we need X. I don't think that I'm certainly not comfortable putting something in a appendix, in a procedure, which is got monetary implications. But I would support what Councillor Gibson said. Thank you.
Councillor Palmer.
But the only trouble is to say that we're going to use the same standards as staff have. Well, they have the right to appeal to an employment tribunal. We have no right of appeal. Yeah. There's only one. You can only get it right once or wrong once, and there's no right of appeal. There is in an employment, so I don't think the two should be conflated. Thank you.
With respect, Chair, when the Standards Committee can sack a councillor, I'll accept that argument. We've already spoken about the pitiful sanctions that can be placed on our colleagues if the hearing decides it. What I'm saying is that the reason I use the analogy with staff is that those procedures have been built up over many, many years. Yes, staff can go to a tribunal because the ultimate for a member of staff is they can be dismissed. Members can't. Thanks, Chair.
Okay, thank you. Councillor Bonney.
I don't think it's going to get used that much, but I do think that option should be in there. So I would agree with Councillor Palmer. And some of this is actually crucial for some members because there's such a substantial issue with their professional careers. So it's not something that can be sniffed at. So I think there does need to be the option, but I think we have to acknowledge that it's probably rarely going to be taken up. I mean, how many have we had of these standards hearings over the last 4 years?
3 in 5 years.
3 in 5 years. Well, there we go. So it's not going to cost us a fortune.
Yes, please go ahead.
May I just clarify who finds the independent person? Because I can see either myself or the monitoring officer finding the independent person and then members saying, actually, I don't like that independent person, I want a different independent person. So,
yeah.
I mean, the investigator, but
an external, I think we're referring to external, I suppose.
Yes, but there is a possibility that once it's happened and the investigation's happened, the person says, well, actually, I don't think that independent person was qualified, knew what they were talking about. So I think if we use independent people, we have to accept that they're there, that that it's not then that we have to go and find another independent person because the subject member didn't like the
Just to clarify for members, obviously we have independent persons who are appointed, and then we're referring to an external investigator. Yeah, just to clarify so that there's no confusion about the independent person and the external investigator.
Yeah, so the independent investigator, that would be chosen by obviously it would be officers that would source them, and I suppose I'm looking for a bit of comfort that when we source somebody, and I can tell you they're not easy to source, these people, they're not sitting waiting for us, actually that will that be acceptable, or will there then be the situation that actually the subject member doesn't find the independent investigator acceptable? Then, you know, it's what's the end line, what's the red line that we say, no, that's it. And that's just a question. Thank you.
Yeah, and I think that is an important point as well, I'm not suggesting that it could be, that it would be used this way, but could be used as a tactic to delay and stall as well, and we just want to obviously make sure that these things aren't endless for the subject member and everybody else involved in it. But I think there obviously is some sort of appetite to make sure that there's the option or the opportunity to have someone external, and if it comes down to the cost of standards hearings that really affects the council's finances, then I'd expect members to take a long hard look at themselves, because there's much more else coming our way that we should all be focused on.
Do we have a consensus, Chair, on what we're adding or not adding to 2 points?
Well, I'll bring in Councillor Tutt.
Thank you, Chair. It was just to say that to have an independent person takes everything away from any thoughts of bias, past history, and it makes it a sensible option that I think should be there.
Yeah, and just again, I just want to clarify how we use the words here, because I think there's plenty of officers internally that can undertake an investigation independently, and I don't think we should be questioning that. And I think with reference to an external appointment, for some of the reasons that Councillor Palmer has indicated, are valid things for us to consider. But I feel that whilst members are coalescing around the idea that yes, that's an option, I don't think at this stage we do have an agreed thing, because the wording is important for members here. So Councillor Gibson, did you indicate?
Yes, thank you, Chair. I agree. I don't think we've reached a consensus in that. I think we're 2 for an actual right and 2 for an option, but I don't know if Councillor Baldock is still indicating for an old thing and may bring us to a different level of numbers or a different conclusion. Thank you.
I'll just quickly bring in Councillor Palmer.
Oh, I mean, you could even say that it's a decision reached by the Standards Committee. That you could have a Standards Committee who says, we look at it, why are the reasons you want to go for an independent assessment assessor, and the committee makes that decision, whether it's been internal or they feel that it warrants going external. Thank you.
Do you have any advice on how that might work?
So I think that's a slightly odd, because obviously Standards Committee meets 4 times a year. Also, the Standards Committee is a political body, so you are surely bringing politics into it by taking it to the Standards Committee rather than having it dealt with by apolitical people. I think that's and also let's say, for example, in relation to there's a determination ultimately by the investigator that there's no breach, then it just seems a slightly, you're doing that. It's a premature thing to have the Standards Committee involved in a standards complaint when at the moment you've not got the point where you're even at a breach yet. So to be honest, I'd be reasonably comfortable with. I suggested that the views of the subject member, be taken into consideration, or something slightly stronger than that. I don't think it should be a sacrosanct thing for members, because you could have a vexatious member who called in an external investigator for something which did not remotely merit it, and no one, reasonably could think that they could. Perhaps the subject members' views would be taken into account and given serious weight. That kind of thing. So their view on it is,
I would like to sort of propose that we revisit this specific point, because I think there's still stuff to get through, and we also have other officers here waiting to present a report, and I don't think we are going to fully resolve this. There are also other members of this committee who aren't here, who may have the opportunity given to them to sort of help us come to some decision. If we look at the recommendations for this agenda item, the first is to consider the comments on the draft code of conduct, which is what we're doing, and the second is to determine what further consultational steps should be taken with the draft arrangement. So we're not really seeking to write it by committee here today. We do have the ability, if members wish, to revisit some of these points, and so I think this has clearly been indicated by members that there's slightly varying views, but overall some sort of direction they want to go on this. So I'd like to sort of park that maybe for now, and we move on so that we can bring this item to some sort of conclusion.
Thank you, Chair. So paragraph 2.8, which is the definition of the monitoring officer, and there's a comment, why is this required? The council has a monitoring officer and deputy monitoring officer. The monitoring officer cannot be an investigating officer, it should be an external investigator. So obviously, again, I'd suggest politely wrong place for this, because it's just the definition of the monitoring officer in the interpretation section. So perhaps, again, and I don't want to revisit the external investigator bit, because we're revisiting that again at some point anyway, so perhaps we just remove that. It's just the definition of the monitoring officer in the interpretation section. Paragraph 3.3, this is in the paragraph entitled the appointment of the independent person. It says the independent person must maintain notes of meetings and discussions with the monitoring officer and provide monitoring officer and subject member, and provide notes of all meetings, and any points raised with the subject member should be agreed in writing. I have no particular strong view on this. I'm not sure if it's in the appointment section or somewhere else, but I wonder, Chair, if the independent person would want to comment on that as it affects the independent person.
Yes, is there anything that you'd like to add to that?
Chair. Sorry, am I on?
Yes, you
are. Yes, we always keep notes, and copious notes on the hearings.
Okay, thank you.
I think that was not quite the point. I think the point was, in actual fact, where the subject member meets with the independent person, a note of the meeting should be kept and agreed with the subject member. That was one point. And the second point was where the independent person discusses a complaint with the monitoring officer, there's also a note of that meeting which is available to the subject member. It wasn't about the hearing.
Okay, I am confident that yes to 1 and yes to 2.
You're happy for that to be added to the arrangements?
Yes.
Because it's not in the arrangements currently.
Okay, yes please.
Yes, Councillor Tutt.
Thank you, Chair. The text doesn't read very well, because it says, and discussions with the monitoring officer and subject provide notes.
This
subject member, or
sorry.
Yes. Yeah, I think that's a typo. It should say subject member. You're quite right.
These are just rough comments on a draft, so it's not intended to be a final clean document. So
no, that's fine. Thank you.
Members are happy to retain the sense of that. Then of course the wording can be tidied up. And as I made the comment earlier, it might sit better somewhere else, but the sense of it is fine. In paragraph 4.1, it's talking about complainants who find difficulty in making their complaint in writing, for example, because of disability, should inform the monitoring officer of any such difficulty, and the monitoring officer will arrange for assistance to be offered. And there's a comment where a complainant is unable to write due to a disability that prevents them from putting their complaint in writing, or there is a language barrier, then a verbal complaint will be transcribed and sent to the complainant for approval before any process can start. I think that adds sort of clarity to what's there already, but I don't think it necessarily changes it. Happy to retain that extra bit of clarity if members are. Paragraph 4.2, The subject member will normally be informed of the identity of the complainant and details of the complaint made against them, but the complainant's identity and or details of their complaint may be withheld at the complainant's request if it appears to the monitoring officer that there are sound reasons for granting such a request. Refer to paragraph 5 of Annex 1 for these arrangements. And there's a comment, how is the subject member expected to defend themselves against something they have no details about? When a complaint is considered serious enough for complete anonymity, should police involvement be considered depending on the nature of the complaint? So, as a matter of law, complainants can have their complaint as an anonymous complaint if it is deemed suitable for that. In my memory, I don't think I've ever taken a complaint anonymously, because obviously when we're talking about local government standards, there are not generally sufficient reasons for a complainant to require the anonymity. So as a matter of law, it could happen. You know, I say we're talking about 3 and 5 years, but I have done complaints across other boroughs as well. I've never accepted a request for anonymity because there'd have to be a clear and serious risk of harm to that person. I've never seen that. And again, the comment in relation to when a complaint is considered serious enough for complete anonymity, should the police be involved? Well, the monitoring officer already has a discretion to involve the police where the behaviour is criminal, and again, that's, I think, a slightly different thing to the anonymity point. I think conflating those two things is probably unhelpful. But that also when a complainant doesn't necessarily need the details of the person complaining against them, but of course in the ordinary course of events, part of the reason why they fundamentally ordinarily do get the details of the person who complains against them is because they know automatically who the complainant is, because when in the identity and the behaviour is identified, it's known who that behaviour was to, for or against. So again, anonymous complaints are exceptionally rare, but I think because the law says there should be the option for it, then it's right that they are in these arrangements, and I leave that as it is. Moving on to the next comment. So specifically about anonymous complaints, the comment is, should not be accepted unless clear document evidence is provided to support the allegation. For example, directorships held in public records such as Companies House. I mean, as I think we've covered this. I've never granted an anonymous complaint to anybody. I've never had the cause to. It would have to be exceptionally severe and evidence for it to be done. So we'll move on from that. In relation to appeal, paragraph 13.1, there is no right of appeal for the complainant or the subject member against the decisions of either the monitoring officer or the hearing panel. And then the comment is, where basic procedures or the constitution hasn't been followed, then the subject member can ask for a review to be undertaken of the decision, and the council should in place a process to review such outcomes. So I think just to be clear, the law doesn't provide in the Localism Act an appeal against the decision of a monitoring officer or a hearing panel. However, because obviously it is a decision of a council, there is the opportunity to have a corporate complaint which would look at the process, and in those circumstances a corporate complaint can be elevated to, for example, ultimately the Local Government and Social Care Ombudsman, but it's about the process rather than the decision. And of course the other thing is because it is the decision of a public body, then it is amenable to judicial review. So you need to understand, when it says there's no right of appeal, what that means is there is no statutory right of appeal, in the way that, for example, in the Licensing Act there is a person aggrieved by this can appeal to a magistrate's court. That's a statutory right of appeal. But there are options open to a member who is uncomfortable with the process to challenge the process.
Councillor Harrison, you indicated.
Yeah, just to be clear, this is all going to be sore-thumbed when these comments and the other comments and all the other comments have been sorted out, because if you've ever done editing, I would have thought, and the council should put in place a process to review such outcomes. And I'm reading so much stuff lately that clearly, I'm not suggesting here, Robin, but some AI thingy has done it, because the grammar is appalling. But yeah, should put in place, is that correct?
I think if I
Yep.
just may make the point that I made to Councillor Tart, this isn't a final draft. It's rough comments on a draft. I don't think there's any.
These are just rough comments that were sourced from members to feed into what we want to do going forward. Councillor Palmer.
Yeah, I mean, we talk about council funds and we don't want to waste it, and then we talk about going to judicial review. That can be very expensive and more expensive than having an independent investigator. So I think having some way of reviewing it, and even if it goes to full council and they look at it and say, well, actually, the process wasn't followed, our own constitution wasn't followed, we don't feel we can have that. Now, the Localism Act may say there is no right to appeal, but it doesn't say that the council can't set in an appeal process. Thank you.
Larissa, yeah.
My question with this would be, who would decide that? Because as the chief, it would take a very brave chief executive to say that a decision made by members is one that should be reviewed. I'm not sure I know any chief execs that would be prepared to do that. The only way that you could do it would be it's a council decision, and the problem with the issue with council decisions, if you make a decision, then there is a way of changing that decision, and that is through judicially reviewing it. Even though if everybody in the world thinks that a decision, and to coin a phrase, is well whack, one still has to go to court to change that decision, even if everybody is in agreement that that decision was made in error or was the wrong decision. So I'm not certain in law how you can overturn a member decision with another member decision. I would seek guidance, but I think the fact that we couldn't overturn our own planning decisions when it was very clear to everybody they were made in error and they were wrong, they were, and that was a decision made by an officer. I'm not certain that I can think of any way that some members can overturn decisions of other members, but that's my just concern raised.
Councillor Miller.
Yeah. If you went to a corporate complaint and was found in your favour, would that then be able to overturn the committee's ruling?
I think in actual fact the difficulty with that is literally, as the chief executive has just advised, is that quite possibly not, because the council becomes functus officio once that decision has been made. So again, it might be the case you go, right, well, actually I'm going to judicially review it because actually they've found a problem with it that makes it worthwhile actually challenging the decision itself. It is an awkward thing. It's like with the examples have been given of the plainly wrong planning notices that were sent out. Can't do anything about it, only the court can overturn it, because once the decision is made, that is the final decision, and there isn't a statutory right of appeal. And I respectfully disagree with Councillor Palmer that we could just invent a right of appeal that went beyond what the law did. That sounds automatically like it would be ultra-virus.
I'll just note that Councillor Baldock had posted a comment. Did you wish to speak at all, Councillor Baldock, on this point?
Yes, thank you, Chair. I think using planning decisions as the same as other council decisions is really wrong. Planning decisions are actually made by officers and they have a legal standing. If we decide that we want to open a toilet in Laysdown and 3 months later we decide we don't want to, we can do that. But it's totally different to planning. So you can't equate planning decisions and other council decisions. I don't think there's anything in law that would prevent a planning or a full council or even another body, PNR, overturning a standards committee decision of the same council. I don't think there's anything in law that would prevent that.
Thank you, Councillor Baldock. Councillor Palmer.
I was going to say the same. I've seen decisions made at planning where it's then called in by officers to be rediscussed and a different decision made a week later. Thank you.
Yep. Robin.
Again, to refer to Councillor Baldock's point about planning being a bad example, that's not before the decision notice is issued. So when the decision notice was issued, council becomes functus officio and it can't change its mind. Again, it's not just planning, it's licensing. You have a right of appeal in statute to a magistrates court in relation to most licensing things, Crown Court in respect of a handful of other licensing things. Council can't necessarily revisit it. So where there is no statutory right of appeal, as I say, I think there is, in respect of the decision, I think to then create one of our own, I think would be, for lack of a better word, dangerous. And as I say, I think there are grounds, as I say, because the process can be challenged through to the local government ombudsman, and also the decision can be challenged in a court, because as a public body decision, it can be judicially reviewed.
Thank you. I suppose, in effect, it's along the lines of what Councillor Harrison was proposing, that if you want this to be an option for local authorities, then maybe it goes to a minister as part of our ask for them to review the standards regime. But Councillor Palmer.
Yeah, and I think Robin's right in some respects. Once the decision's been issued, before the decision notice is issued, then the member should have the right to ask for the decision to be reviewed by full council, and that would be, I think, more than acceptable. And I think actually the chair's made a good point that it's something to add to the government to say, can you look at this, because having no right of appeal can cause quite serious concerns for some members. Thank you.
Okay, thank you. We don't have a full proposal from Councillor Harrison yet, but when I allow that to come, perhaps you wish to suggest an amendment. Councillor Baldock, would you just like to speak again regarding your further comment in the chat? No? Okay. Were there any other member comments on this? No. Okay.
Are we moving on, Chair?
Me.
Oh.
Yes, sorry. Councillor Baldock, I did call you, but I didn't realise you were having connection problems. Would you like to speak regarding the further comment that you've made?
Yeah, it's very brief. And you referred to it earlier yourself. I do think there's a time limit should be put on from when a complaint is made or begun to when it gets heard. Being the subject of a standards complaint is very stressful. If it's allowed to drag on and on, it is really really unfair on the subject member, and causes undue stress, and it's not good practice to allow something like this to drag on for so long. So if we're looking at revising the standards process, I think we should have a 3-month cut-off point where there's only exceptional circumstances it can take longer than 3 months, i.e. if somebody's ill or something. But most standards committees should not take more than 3 months.
Okay, thank you.
I think that's what was said by the woman who spoke to you all.
In our training session, you mean? Yep.
Yes.
All right, thank you, Councillor Baldock.
I think the only thing is that we're dealing with, in the arrangements at the moment, the appeal. So I think that's a comment potentially for another part of the procedure, and there's quite a lot of timings introduced into later in the procedure, which would, give us a sense of how long we think the process would take. I don't disagree with the general sense of it, that ideally these matters are dealt with swiftly. Just a comment with no agenda, but obviously that does also rely on the subject member responding as well, because if there was an absolute hard fast rule that if after 3 months there's no determination, it falls away, the subject member just says nothing for 3 months, then it falls away. So that it couldn't work quite like that. I think we're moving on to 14, discontinuance of action. In the event that the subject member has died, is seriously ill, or has ceased to be an elected member or co-opted member of the borough or parish or town council, the monitoring officer may determine to end the complaints process, and the comment is it should just end. I think again there's obviously been a certain amount of flex there in relation to may rather than will end the process, but I think it's because it's obviously died / seriously ill or ceased to be an elected member. I understand across the country has been situations whereby a person has ceased to be a member by virtue of resignation and then become a member again very shortly thereafter, thereafter in a by-election, and then the arrangements were such that then they had fallen away, so it was a way of just avoiding any consequences in relation to poor behaviour, which I think is why it's a may rather than must do. But I mean, obviously, in the event that a subject member has died, I cannot imagine any monitoring officer that would continue with the process after a person has died. Again, similarly in relation to seriously ill, I wouldn't be minded actually to change that paragraph. No, thank you. There's a, I think, suggested additional paragraph 14.2. The process to decide that a possible breach of standards has taken place should be decided within 14 days of receipt of the complaint, and the subject member informed. If longer than 14 days, then no further action can be taken. I think that goes back to my comment on it would rely on the subject member also being willing to make a comment on it, and if they didn't comment in 14 days, then it would fall away. So that can't possibly work that way, I don't think. I don't know if it was something slightly different. Also, it is under the paragraph discontinuance of action. So, yeah, I think 14 days is unrealistic, and obviously requires the input of a number of people.
Councillor Palmer, you indicated.
Yeah, it's the possible breach. It's if they take longer than 14 days to decide that the breach has taken place. Because once you've got the complaint, it shouldn't just drag out and then inform the member a month later or 2 months later. It should be within a reasonable time. It's not saying the process needs to be completed. It's saying the process to decide that the breach has occurred should be taken within 14 days of receiving the complaint.
Yeah, Robin?
Determining that a breach has occurred is ultimately only the gift of a standard subcommittee in the event that the breach isn't accepted. So I think what you're referring to is an initial assessment decision. You're suggesting that, and so again, I don't necessarily disagree with you in relation to a swift initial assessment decision where that's possible. I think 14 days is optimistic. But we're in 14 discontinuance of action. And again, what about the rights of the complainant who's made a complaint in relation to their complaint being fairly heard if for some reason 14 days or 28 days was not possible for legitimate reasons?
I could accept the point of view, but I think there needs to be a time for the initial assessment to be made.
So I think, again, there are timings later in the document that I think perhaps we'll pick that up there. Are you happy that I take this out of here because it's not the right place for here, and that we'll pick that up elsewhere? Paragraph 15, revision of these arrangements. The Borough Council may by resolution agree to amend these arrangements and has delegated to the monitoring officer and the hearing panel the right to depart from these arrangements where considered expedient to do so in order to secure the effective and fair consideration of any matter. I referred to this earlier on, saying there could be a possible risk of these being well-intentioned but actually cause harm. Can happen. And the comment was this should be removed. There should be no blank check. So...
Councillor Palmer.
Yeah, I just feel when you give unbridled power to someone, it's unclear. Well, the right to depart from these arrangements, well, who decides? Where considered expedient to do so, who decides? To secure effective and fair consideration of the matter, who decides? Because one party might say, I don't think it's fair, I don't think it's effective, I don't think that was expedient. So And to give unbridled power, we have procedures in place that should be followed. And if we don't follow the procedures, or we decide, well, we can adjust it on this occasion, but we do it this way, we do it that way, it's just a fudge. So I don't think a blank cheque should be given to change things willy-nilly without a resolution of the council or going to standards committee, etc. Thank you.
Thanks, Councillor Palmer. Councillor Gibson, Pete.
Thank you, Chair. I'm comfortable with the delegation to the monitoring officer and hearing panel the right to depart from these arrangements. I think where expedient is probably more generous than is required, and so given that this is an extremely detailed document that lists a number of options and a variety of processes, something more along the lines of in exceptional circumstances where required, where necessary or where deemed necessary by a majority of the panel or something in that family would feel more comfortable, because I agree with Councillor Palmer's concerns. Where expedient rather leaves the room open for the chair of the panel to go, well, I'd quite like to be on my flight at 3 o'clock, should we crack on? Which is clearly not what we're going for. And so there's, I think, where necessary and in exceptional circumstances would sit more comfortably for me. Thank you.
Well, there, Councillor Tutt.
Just again, who decides what necessary means? It's back to expedient, and it's not really a very clever definition.
Yeah, I mean, I think because we've also just spent so long going through all of these, to then sort of see a point that basically says, oh, well, we've just spent all this time discussing it, but we'll just get chucked aside. Does feel a bit, but I suppose there are... Yeah.
I've got no issue with leaving it where I think the comment was happy to leave it, which was the Borough Council may by resolution agree to amend these arrangements. I just put it out that the only risk is that in the circumstances where you come across a procedural unfairness caused by these arrangements, that you can't rectify it because there's no room. That's the intention of that. It's not the intention that you drive cart and horses through these arrangements every time you get something. It's that in the event that there was a procedural unfairness caused by these arrangements, that you can fix it. That's the intention of that. And if you don't have that, then the procedural unfairness continues by virtue of the arrangements.
Yeah, I suppose the expediency point then is a bit... I'm not entirely sure who posted that comment. I can't see. Was it Council? Right, okay, thank you. So there's sort of a proposal there that we just cut it at that point. I don't know what members think of that. Yes, Councillor Palmer.
I think we cut it at that point because I think we're going to decide this and we should decide any amendments. Thank you.
Any other comments from members at all? No.
That is duly cut.
Thank you.
Moving on. So paragraph 2.1 of Annex 1, the complaint will be assessed by the monitoring officer against the legal jurisdiction test in paragraph 2.2, and if applicable, the local assessment criteria test in paragraph 2.4 below. The monitoring officer may assess the complaint in consultation with the independent person. Notes, minutes of this the comment is notes, minutes of this assessment must be made. Perfectly happy with that?
Yes, thank you.
Skipping on to the next one. So there's a timings point here. The local assessment criteria test. So the suggestion is the alleged misconduct happened more than 3 months prior to the submission of the complaint. So there's effectively a delayed complaint being made. The suggestion is that should be reduced to just 28 days. For what it's worth, I'm not in favour of that. I think there is I think previously I've generally used 3 months as a sort of a general yardstick. I think sometimes very egregious behaviour potentially can be looked at longer ago than that, but this would limit it to 3 months. But I think 28 days is a particularly short time to make a complaint. I think sometimes folks need some time to think about things and ruminate on it before they make a complaint.
Thank you.
Thanks very much. Another one, the complaint has been the subject of an investigation or other action and there is nothing more to be gained by further action being taken. And there is a question, what about where a complaint has another legal remedy, for example, defamation? So for what it's worth, I don't sure that this would necessarily deal with the interaction of defamation, but my approach would be where there was another regulatory body or there was another legal process going on, that I would put on hold any standards matter and allow that matter to determine it. So, for example, if there was, as a matter of interest, and you get this with parishes, the clerk making both a grievance against the parish and a code of conduct complaint against a member, I would tend to look to park the standards matter and allow the employment tribunal to determine whether or not the employment of that person had been impacted by the behaviour, and that would feed into how you dealt with the standards matter. So this is a reason whereby you would not take a complaint forward, and the point is it's because there has been another investigation or other action, therefore there's nothing further to be gained. So I think that the comment is this an example of that? And potentially that is, but I don't think it's just a comment rather than an addition. So I'm happy with the general thrust of it, but I don't think we need it in the document per se.
Hold on, Chair.
Okay, Councillor Palmer.
I don't. You see, if words are said, and someone is threatening defamation, and a standard hearing takes place, that could be used in a case of defamation. So, you know, and when people are told, well, we might take it to a standards hearing because it's better than facing defamation, well then that's a choice for the member. The member should be asked. It shouldn't just be we're going to do it. And there was a case that went to the tribunal under the previous standards regime, and it was Copeland versus West Lindsey District Council, and the upper tier tribunal said it was unfair to use the standards regime when the member of the public had a case for defamation. And during the standards training, it was made quite clear by the lady who did the standards training that even previous case law under the previous regime shows an indication of how things should be done. So, and believe it or not, for the last 3 to 4 years, up to about 2018, the Copeland case was reported in the annual review of the Standards Committee. So it was something that's well known, and it was being reported since 2011 as a reason for not using a standards case when a case of defamation has been led. So I think we've got to be very careful if there's another way that someone can take legal action, that the standards regime isn't used instead of that.
I say I'm well aware of that case. It's I think I'm not sure it's even upper tier tribunal, but it's a tribunal case. It isn't binding. It's decided on the same facts, and it is in the previous standards regime. So, unfortunately, I don't think we can give an enormous amount of weight to it. But again, in relation to the specific points that we are looking at in relation to these arrangements, the comment is a reason why you will not take a complaint forward is because the complaint has been the subject of an investigation or other action, and there is nothing more to be gained by further action being taken. And I'm saying that could be where, for example, an action in defamation had been taken, completed, and the person had been punished and had been fined and that sort of thing. So, well, where's the value in taking forward the standards at this point, because the matter's already in the public domain and the wrong has already been righted. That's what I'm talking about.
But what about if they go to a standards hearing, the standard hearing says, oh, we've made a decision, and they go to defamation, and the court says there's no case for defamation here, don't know what you're talking about.
Well, I mean, they're not applying...
So you've had a standards hearing, made a decision contrary to what a judge. So it seems ludicrous, and particularly, and it was quite clear in the standards training, which I believe the chair was present. And many of the cases she gave, she actually said these were under the previous regime, first tier, and it shows the way and the flavour of it. And it's quite clear in Copeland, where there is a remedy of defamation, it is wrong to use the standards regime. Thank you.
So I've already spoken about Copeland, and I say in relation to the court making a determination that there has been a defamation, and the standards regime in respect of, for example, disrespect or bullying or bringing the authority into disrepute are not applying the same test, they're not working in the same way, and that either which way though, we're trying to talk about bullet point I. The complaint has been the subject of an investigation or other action. Do members want to specifically reference, for example, defamation in there as a reason not to take the matter forwards, or just leave it as it stands, bearing in mind that it could include defamation?
I think you should include defamation in there.
Does that have the agreement of the meeting?
Remedy in court, you should not use the standards. The standards regime should not be used where there's another remedy, particularly a legal remedy to a higher court. Thank you.
Yeah, Councillor Bonney.
I think those of us that have been on the receiving end of certain actions, that is one that is quite honestly not very nice to look down the barrel of, and is frequently used by or thrown at elected members, defamation. And I think you have to be exceedingly careful that you don't undermine freedom of speech and effectively undermine their position. So I do tend to agree with the councillor there.
Councillor Gibson.
Thank you, Chair. I agree with the monitoring officer that they're separate and they by separate judgments. So I think the solution that might allow us to compromise and move forward before I die of starvation is that the complaint has been or may be subject of a different investigation. So adding or may be allows that possibility or clarifies that possibility is being considered. I agree with Robin that it probably is being considered by the monitoring officer anyway, that's part of the process, but adding or may be makes that clear that is a legitimate reason why we might not do it.
Councillor Jays.
Thank you, sir.
I suppose you might get a case where it's not just about the defamation, it's about the rest of the behaviour around that. So I think the defamation could be shelved and that can go to a court if need be, but there may be other things. So to include defamation might not be right.
Yeah, that's sort of where I'm coming from on this. Yes.
And for expedience, we've dealt with the next 4 bits of green. Skip to 5.2, Chair.
Thank you, Councillor Jays.
I mean, I think I need very careful thinking about, to be quite honest, because when you get a letter threatening defamation, that, to me, is bullying of a member.
If we...
If a monitoring officer ever says, well, actually, I think it's better to go to standards than face defamation, without even asking the member, then I think they've exceeded, their authority, but having something in there protects the member going forward. Thank you.
I think a way forward could be to make the amendment suggested by Councillor Gibson, and that we note that this is still an area of further consideration, so that I think what will help in all of this is seeing this as a cleaner draft with all of these comments noted, and that, along with the previous point about the right to an external investigator, can be revisited when there are other members of the committee hopefully able to make the meeting as well. So
take that from that, Chairman, that we're moving on.
Yes, please.
So 4.3 picks up the all complaints must be investigated by an external body or person. As I say, we're revisiting that, aren't we? And in fact, 4.4, what about if the complaint has another legal remedy? We're revisiting that too. 4.5, the investigation might prejudice another investigation or court proceedings, such as defamation. Another part of the revisiting. There is no right of appeal to the monitoring officer's decision. The comment is, I'd like to see a review to an external body. I think we've already covered that. As I say, how that can be done.
Yep.
Just by way of comment, actually, maybe the thing that would make that clear is there is no statutory right of appeal to the monitoring officer's decision. That's bear with. Paragraph 5, confidentiality. As a matter of fairness and national... So this is paragraph 5.2, sorry. As a matter of fairness and natural justice, the subject member will usually be told who the complainant is. We've covered this under anonymity earlier on, haven't we? So, and we've agreed that it's legal, but it's very rare. I've just inadvertently gone past one. This is paragraph 6.2, subparagraph E. The conduct complained of appears to the monitoring officer not to require a formal sanction. There's a comment, or the final decision should be made by the Standards Committee or a working group. If the complaint is then progressed, the working group can then not be on the hearing panel. So this is about informal resolution. So informal resolution may be the simplest and most cost-effective way of resolving the complaint and may be appropriate where. And then it's E, the conduct complained of appears to the monitoring officer not to require a formal sanction. But then that's then saying that actually the monitoring officer can't make that decision. There's a decision on that should be made by a standards committee or a working group. I mean, there are no standards committee working groups. There's obviously standards subcommittees. There's the standard committee. I mean, in fairness, if you take away the decision from the monitoring officer, you completely fundamentally change this. Say the conduct complained of appears to the monitoring officer not to require a formal sanction. That's effectively a delegation to the monitoring officer. So I don't think you can have that there. Are we happy to take that out? Thank you. That's right. We're up to the complaint form, so we're making fine progress. There we are. I think appeal. So there is no right of appeal against the monitoring officer's decision. I mean, I think we have covered this potentially. So it's like, and again, we can add the word statutory to that as well. There is no statutory right of appeal. So this is Annex 2, 1 preliminaries. The investigating officer will be appointed by the monitoring officer and will be aware of their obligations under the UK GDPR and Data Protection Act 2018, the Equalities Act 2010, the Human Rights Act 1998, and the suggestion is added to the Localism Act 2011, which seems fair given that that's what the arrangements are under. So yep, happy with that. There's 1.2. The investigating officer is responsible for gathering all the facts, documents, and where applicable should be for interviewing witnesses. Again, this is a repetition of the person being external, so obviously we know we're going to revisit that, so we won't do that. We've got 1.6. The investigating officer will notify the subject member and complainant of their appointment, normally within 20 working days of being appointed. If all members are happy with that, that's fine. Oh, I see, of course, yeah, the change is normally, so it's within 20 working days, but the suggestion is normally within 20 working days, which actually appreciate a bit of flex on that. 1.7, it may be necessary for the investigating officer to agree with the subject member which documents will be submitted in evidence. This will generally include documents that will be relied on or in support of the subject member's case and which are relevant to the complaint. A date for documents, etc. should be set. Oh, I think that's perfectly fair.
Just on that point, because it was made clear during the training that a subject member can actually apply and put any documents in that he sees fit, and it should not be down to the monitoring officer or the investigating officer that the subject member can't submit certain documents. She was adamant on that, and I think people who were there would remember that point.
Yeah. I think she did also make the point that it couldn't be copious amounts, that just is, an exceptional amount of content that has to be considered.
For clarifications, yes, she did say that, but that's anything that's brought in on the day. That you can't turn up with a stack of documents saying, here it is, this is my defence. That has to be submitted beforehand, but a small amount of documents on the day, a 2 or 3 page, could be accepted on the day. But beforehand, even if we said it's got to be 14 days beforehand, you could put in what you like. There should be no restriction. The investigating officer can't say, the subject member can't put that in, and the chair of the committee can't refuse it. Yeah. Thank you.
Thank you, Councillor Palmer.
So paragraph 4, deferring an investigation. 4.1b, the investigation might prejudice another investigation or court proceeding. There's the comment again about possibly defamation, and we're bringing that back, aren't we? 4.3, where it's clear there is an ongoing police or other investigation. Again, defamation, we're bringing that back. 4.6, defamation again. We are into Annex 3, which is very exciting. Pre-hearing procedure, 1.1e, where the subject member requests the whole or any part of the hearing to be held in private. So in order to allow the hearing to proceed fairly and efficiently, the monitoring officer may, in appropriate cases, use a pre-hearing procedure to identify E, whether the subject member requests the whole or any part of the hearing to be held in private. And the comment then here is the default position B must be that all hearings are public hearings. And again, I think generally speaking, the starting point is hearings are public hearings, but because of the nature of them, sometimes they are exempt. There's no reason why I can't have the default position is that all hearings are public hearings, because obviously it's not all hearings must be public hearings. We couldn't accept that.
No.
The default position is fine.
Yeah, I think that was another point that was just sort of underscored in the training, is that it is the default position. So I don't see a problem with that.
F, whether the subject member requests the whole or any part of the investigation report or other documents to be withheld from the public, the default position must be that hearing. Okay, so that's the same point. Public hearings are public. Just scrolling down to the next comment. I think we might have had all of the comments, but I just want to get through to the very end to make sure that we have. Oh no, I found one. 11.3, having taken into account the independent persons. Oh no, this is one we cut out for Councillor Hunt. It's all right. It's No, we are done. Thank you very much, members, for your time doing that. I appreciate you've taken quite a long time going over that. I appreciate your efforts.
Okay.
I realised that the next thing, was good determination of the next steps. And if I may venture a suggestion,
yes,
my suggestion for the next step with this is, having made some progress with this and having narrowed it down to a relatively small number of ongoing matters, would members agree to the existing text now being consulted on with all members?
Yeah. Okay, I think I still need a proposer and a seconder for the recommendations in light of that suggestion. So can I have a proposer, please? Councillor Jays. Seconder, please, Councillor Palmer. And that is, just for the avoidance of doubt, if I can get back to that page. Done this at length in any case. So the recommendations were: 1, to consider the comments on the draft code of conduct arrangements, which we have just spent a little bit of time on, and 2, to determine what further consultational steps should be taken with the draft amendments. And there was a suggestion there from Robin about this. So all our members in favour of those recommendations? Yep. Okay, thank you very much. The next item was item 6, member development strategy, but if members are okay, I'd like to propose that we move item 7 forward, which is the member DBS check proposal. Are members okay for us to move that forward? Yep. Okay, item 7, please. Let me just get back to my page in the agenda. Okay, so, oh no, let me skip that as well. Item 7, which is the elected members' DBS proposal. I have Steph Curtis here, Community Service Manager, to introduce the report. So I'll hand over to Steph to do so now. Thank you.
So, good evening, everyone. This report discusses proposals to introduce DBS checks for members following the request from the Housing and Health Committee on the 5th of March this year to look into this matter. Although there's no statutory requirement in place for DBS checks for councillors, there are some pieces of legislation to note. Section 27 of the Localism Act 2011 requires local authorities to promote and maintain high standards of conduct by members and co-opted members of the authority. And the Local Government Disqualification Act 22 introduced new grounds on which a person is disqualified from being elected to or holding certain positions in local government, including the position of a councillor. There is a potential that the public may be at risk if a councillor has a serious conviction that the council is not aware of, as well as a reputational risk if they are found to have criminal convictions. Levels of DBS checks do vary depending on the role that is being carried out and whether it is regulated activity or not, as set out in the Safeguarding Vulnerable Groups Act. However, for Svalborough Council members, none of these activities would be considered that. Therefore, only a basic DBS check could be completed. Introducing a voluntary process for all elected members to complete a basic DBS check would ensure that the council is fully aware of any convictions that affect the suitability of a councillor to work in the public domain and could bring the council into disrepute, and it would provide added assurance that the council is committed to promoting high standards. If a DBS check did reveal an offence, the recommendation within the report is that the Chief Executive and the leader, with support from the monitoring officer, would consider next steps as outlined in the report, considering the risks and mitigations that might need to be taken into account. The committee is therefore asked to discuss the introduction of basic DBS checks for elected members at the time of election and then 2 yearly until the point that their appointment ceases, and to recommend to full council that this process be adopted, and to agree that the Chief Executive, in conjunction with the leader and support from the monitoring officer, promote the process for failure to complete the DBS checks and if the check did reveal an offence. Thank you.
Thank you very much, Steph. I think I need to get a proposer and a seconder for those recommendations, then we'll open it up for questions and comments. So is there a proposer for these recommendations? Councillor Harrison, second. Councillor Palmer. Thank you very much. I'll now open up. Councillor Harrison had indicated a wish to speak.
Yes, this came up at Housing and Health when we were discussing safeguarding. I'm not going to say everyone in Swale, but a vast majority of people that we talk to were under the impression that councillors were already checked. We'll put it as baldly as that. And on the odd occasion where people have been interested in engaging, and I said, well, no, they don't even do it for the members of parliament, you know, and it was, wow. Yeah. Local councillors, over the years, you get invited into, I'll be honest, I'm a bit more cagey these days, but I mean, it used to be automatic that you went into people's houses to talk to them, vulnerable adults, children. You know, you are a leader in your community. And I think that the very least that your community could expect is that the council has done a very basic check. The only thing that I would query, I was hoping that you might have said something during your intro, Steph, is why every 2 years? When this came up when I was actually on county, that's when they started it, and it was every like term, except if you get in on a by-election, in which case you'll have it done straight away. When we started it at county, we actually did it in year 3 of a 4-year term, and there were people who got back after the 4-year term who had to have it done. Well, not had to, because it was voluntary. It's voluntary in that way that we know what's voluntary, arm up your back, and they had to have it done again. So I was wondering why it was suggested to be every 2 years, particularly as in this day and age, I'm not one of them, but you can't move without being on social media. So if 2 years into your term, having had your basic DBS check, I still call it CRB, you do something which would then show upon a DBS, let me assure you, Joe and Josephine out there will have it on social media before you can blink. Indeed, they'll have it on social media whether it happened or not. So that was why I wondered why you'd put in the 2 years, because I think it would be more appropriate to have it on the term, beginning of each term of office of a councillor.
I mean, it was simply just we did some research around what other local authorities did, and there were a couple that did at the point of appointment and then sort of partway through the term. But again, it's sort of over to you guys as members in terms of what frequency you would like.
Thanks. And whilst being happy to move the recommendation, I would be happy that it was recommended to each term of 4 years, or as appropriate with by-elections, blah, blah, blah. I know, because I've read all the legislation, and KCC is the Social Services Authority, but as I say, it isn't the fact that you sit on a Social Services Committee, you could be on that panel that looks at safeguarding children and all the rest of it. We, in my humble experience, can't talk for everyone, get invited into people's homes. We are trusted members of the community. And I think that, you know, that beholds and behoves us to actually do the best we can to make sure that, you know, certain things don't slip through the net, like, you know, that place up, that, you know, the Great House as they call it, 5 years after you've died, they found out that you've been doing all sorts of things for the last 30 years. Now, maybe if there'd been some sort of check, it might not have gone on so long. So it's just really, we sit there, we do the safeguarding training. Oh, aren't we good? We've done the training. We know about this and we know about that. Well, okay, let's go that little extra step, but once per term of office or part thereof, whatever.
Okay, well, if that's okay, Councillor Aronson, we'll take that as a slight amendment in a moment, but just got some other people wishing to speak. Councillor Worcester, you indicated online.
Yes, please, Chair. Thank you very much for allowing me to speak this evening. I'm sorry I didn't put in a pre-request for the meeting to be able to join the meeting this evening. Sorry, everybody. On this particular element, I'm very pleased to see the Borough Council taking this seriously. I absolutely believe that this is part of, as we're told as councillors, not just being part of what in reality happens at the council, but what is the public perception about what happens at the council. These checks are nationally recognised and they do help us reaffirm that councillors can be trusted. So on that respect, I do absolutely support Councillor Harrison's point of view about it being termly for our election cycle, but I do feel the wording needs to be adjusted to say that if the termly report is to be accepted, there should be a very, very strong expectation on councillors to voluntarily come forward if they feel that within their term of office something happens to them that could be reflected on a DBS check, because in other organisations, it doesn't have to be 4 years. It could be once in that cycle of where you are in that organisation. I think we're better than that. I think we set a better standard than that, and we actually make it much easier for our political leaders of our groups on the council to say if a councillor moves beyond that, they've got much more allowance to kind of help their own member choose the right path. And I want the right path to be chosen irrespective of party and irrespective of council. So that's my two elements. Absolutely support it, but would like there to be wording in there to absolutely underline that it is a councillor's responsibility to come forward and protect themselves and other people in their community by letting their organisation know if something happens between DBS checks that would affect that standing, because you can always apply for a DBS check again after that just to make sure, and it will put the council in absolute transparency as to where that member sits with regards to our own sort of rules and regulations. Thank you.
Thank you, Councillor Worcester. Councillor Braun, please.
Yeah, I mean, this is something I've raised to members of my group over the past year and a bit. I've been at an event that also has a nursery on site, and I was invited to have a look around. And you know, the staff there were surprised to learn that we weren't DBS checked. I just think it makes sense.
Thank you, Councillor Palmer, please.
No, I agree. I do think it makes sense. Will the council recognise people who hold the DBS? I actually hold Enhanced with Children, and I'm on the yearly update service. So, you know, you can have my reference number and you can type it into the computer and it will tell you every year you can do a physical check. I think it's a good thing. I don't think we can force people. I mean, it might be down to political groupings to encourage their members to go forward for it. But yes, I think it's good. And there was something that was said that Councillor Harrison said, and I just wondered if those appointed to the CSP, because of some of the subjects there, should they not have an enhanced DBS? And it's just something that clicked in with something that was said. Thank you.
Charlotte, do you want to take that point?
Yeah, thank you. So on your 2 points, I think if your DBS that you've got for another reason is passportable, which is sounding like that you can, then I think that would be acceptable. Obviously, sometimes they're not; they're just done for a specific purpose. So I think we'd need to look at the individual circumstances. Regarding the Community Safety Partnership Executive Group, it is a strategy group, so individual cases and individuals should not be discussed. I know there is obviously sensitive information, but as councillors you receive a lot of sensitive information and would be, you stick to the confidentiality arrangements around that. So I don't think it is required for that purpose. Thank you.
Yes, go ahead, Lewis.
And also, if the police have concerns about any elected member on the Community Safety Partnership, they do write to me as the Chief Executive to advise me that they have concerns and what those concerns are. So without having a DBS, if the police have concerns, we absolutely know about it, and then we talk to the group leader and raise those concerns with the group leader, and it's up to the group leader to decide what to do.
Councillor Bonney.
Yep, thank you. Yeah, I agree with getting DBS checks. The problem, and I think the nub of the issue really is then what can you do once you've found that information? And you talk about group leaders. Some of these people won't necessarily be in groups. And that's an issue, and how you deal with that, because you can't have a rule for those that are in groups that's separate to those that are independent or other. So that's what I was going to raise. But it's then what do you do with that information, and how do you then safeguard people? Because you can't. What can you do? Can you tell them they can't go out into their wards, etc.? You can't suspend them as a member, can you? Or kind of. Well, I know you'd probably get a taser on them, probably. but it's all well and good knowing information, and it is only a point in time. It's on the day that check was done. I mean, I had one done from when I was a governor, and there's education ones. I'm not sure it's necessarily passportable, but it's done at that point in time, as we've all aware. You can be convicted at any moment in time if you've done something wrong. So, I mean, I do agree that maybe twice in that cycle, so it picks up. But yes, maybe the onus should be on the member, and them then not reporting that, because quite often it gets reported in the press anyway, so most of us would be aware, as we recently have been. But yeah, it is what we do with it, and we're in a difficult position because we might then know the information and not be able to do anything with it.
I'll just bring in Charlotte at this point.
I think, they are really valid points about what you can. We obviously couldn't stop somebody being a member if they did have a past conviction come up, unless it was, the eligibility criteria. I think what is good practice, though, and particularly in safer recruitment and organisations that do work with children and vulnerable people, the best practice around safer recruitment is if you're very visible about it and saying, actually, this might come back, it's actually a bit of a deterrent. And that has a process. I think also understanding risks always helps us mitigate them more. So again, it's that risk assessment. So DBSs aren't perfect. Some people may have committed offences that have never been charged or investigated. There might not be enough evidence and things like that. So they aren't the be-all and end-all of everything. I think it is just another tool to safeguard our residents, and a signal about how the council takes certain things seriously. And I think that was the intention that I felt that came out from the Housing and Health Committee's discussion going forward.
Councillor Gibson, then Councillor Harrison.
Thank you, Chair. I agree with all that's been said. I think it's eminently sensible and very helpful, probably, in our role as councillors to have DBS checks. I have had governor DBS checks and a variety of others, but obviously they're not always passportable to things you might do in the community in a wider context. So I think this is eminently sensible. I'm very relaxed about the regularity with which we do them. The more the better, but I share Councillor Bonney's concerns about knowing and not acting, but I'm not sure there's an easy solution to that. Thank you.
Thank you. Councillor Harris. Yep.
The other thing that we can do, so there's two elements about knowing. obviously we can put in risk assessments that not only protect the public and staff and other members, but also protects that member themselves. There's also spent convictions where we can actually work to make sure that things like addresses aren't given out. So, you know, it's not just about a sanction, it's also about, if we have that information, we can protect that member and also other members and officers and staff, and through the risk assessment process. And that's what Charlotte and I do. We come up with a risk assessment and, you know, doing it at the moment, and to protect staff, but also the member themselves. So there is things, if stuff comes up, that we can do that to protect people.
Councillor Harrison, please.
Yeah, I think there's two strands here. Number one is the principle, well, the agreement that we should be doing this, which I could be wrong, but I thought would come under the remit of us recommending to council. Maybe not. So number one, we do it, but whilst we're sorting out the wherewithal and all the rest of it, you actually look at these other issues. And of course, when we get back to my proposal, we could always do for example, if a member's DBS check comes up like they're second to the axe murderer or Jack and Jacqueline the Ripper, how do we sanction them, you know? It'd be quite a good example, wouldn't it? But I think that it's actually getting through, because it's took a while to get this far. When I say a while, I mean quite a few years. I never give in. Let's agree that we're going to do it, and then, yeah, but what about this, and what if that, and what if that? Because Monique's right, not all of us are in a group. If something came up about one of our group, I would be extremely surprised, because our group, like I thought the main political parties, are all vetted to within an inch of their life and beyond. But obviously independents as well. But I think we're laying down a marker to the public and saying, these are our standards. This is what we think going forward. You can't do anything retrospectively. But going forward, these are our standards. This is the sort of thing that we think. And maybe it will also give a bit of impetus to other organisations to pursue it. As I say, I've always found it extremely strange that the 650 now members of Parliament do not have to have a DBS check. They can go into schools and God knows where else with impunity, rally kids to go off on beach hunts and maybe other things. I'm not being specific because there was, I'm not saying there was anything there, but yeah, people trust you because you're the MP. People trust you because you're the local councillor. But as I say, I could be Jacqueline the Ripper. I'd be very surprised because it would have been in the papers by now. But so yeah, let's agree the principle, Chair, and then perhaps we can have at some point in the future, this committee can actually look at all these what ifs on the basis that we ain't going to get a taser yet.
Councillor Worcester, can I just check if that's a new hand that you've raised?
It is a new hand, and I'm quite accepting of you only allowing me to speak once. So, can I have permission to just really quickly add something else? Please,
Yes,
Chair?
very briefly, please.
Really briefly, I just wanted to find out what our position was on reviewing the policy, because I agree that these sort of policies and ideas can't be brought in as a fail-safe. It's a step in the right direction. It's not placebo. It's not going to solve. It's not a problem solver. You're never going to solve a problem like safeguarding with just something like this. But for my reassurance, I believe other members' reassurance, I think it's something that should be reviewed on a regular basis to make sure that when you put a generic policy in or generic something like this that works for other organisations, it really should be initially put in and then reviewed at a later date to make sure that it suits the organisation's purpose, which should go some way into allaying members' fears that, for instance, we could go further on some aspects than the other. So pretty much the same as Councillor Harrison's point of coming back to details at a later date. but I would like reassurance that it will come round in a timely manner to make sure this, along with safeguarding, is something that's at the top of the council's priority list and is seen to be at the top of the council's priority list, because it affects so much more than just children, just vulnerable adults. It's something that affects everybody. Thank you.
Yep, Charlotte.
Yeah, thank you. So, in response to Councillor Worcester's comment, this point actually got raised when we were refreshing the safeguarding policy that obviously sits with the Housing and Health Committee principally. So I think the intention was, if this was approved, obviously we could amend the safeguarding policy to include that, and that is under a regular review cycle to make sure that it's fit for purpose. That already covers obviously staff and volunteers and the like within that policy, so it is really about enhancing the detail and probably sits quite neatly in there and would get captured by that regular review process.
Okay, and so seeing as this was sort of referred to us by the Health and Housing Committee, some of these further bits could be picked up there and brought back to us if they feel that's necessary in light of that as well. So we did have a proposer and a seconder for the initial recommendations. Councillor Harrison, did you still wish to amend it so that it was a...
As amended, yeah, termly.
Okay. Yeah. Termly and... Yep.
Yeah, no, I'll second.
Okay. So that amendment is proposed by Councillor Harrison, seconded by Councillor Miller. Are members in agreement? Okay. All right, no problem. Would you like to speak, Councillor Jays first?
Thank you. I'd like to see it go further than we've got on here, which says 2 yearly. I'd like to see it annually. I think the more checks, the better.
Councillor Bonney.
Did we iron out the crinkle on group leaders?
I think that's probably a difficult one for us to... Councillor Harris.
That was my point on, can we agree the principle but then get a report back on the wrinkles, if you like, that have been raised. But I wouldn't want us... this is what we do. This is what we did on the Code of Conduct and all the rest of it. That thing we did just now, so long ago I've forgotten. We spend so much time, but let's dot the I, no, let's cross the T, and the actual principle of it, what I'm saying is, let's agree that we'll have a DBS check once every term, right? That's one thing out of the way, and then things like, but what if you ain't got a group leader? What if you haven't got this? What if this? What if? All the what ifs can come again, but they shouldn't be holding up the fact that we would like DBS checks for councillors. Thanks.
We've got two different proposals there. One is for annual DBS checks and one's for a termly DBS check. So they're two separate amendments. We could take Councillor Jays, if you want to propose that. Is there a seconder to your proposal, Councillor Bonney? Can we take a vote on that in the first instance? That it will be annual DBS check recommended by this committee. Those in favour? 2. Those against? 5. So that amendment falls. We'll now take Councillor Harrison's amendment that it's termly, and obviously with some allowance made for if you're elected through by-election and so forth. All those in favour? That's 6. Those against? 1. Yes, please.
So in the event someone doesn't have a group leader, we would talk directly to them, in the same way that that actually group leaders have no power other than to suspend somebody from the group, which would make them an independent. We would talk to them. What we can look at a later date through this group is the possibility of reporting, not by name, but by group, how many people haven't gone through the process. That would be a way of doing it, but we can support independent members to get that done. We have 2 independent members at the moment, but we can support them in doing that, and it's potentially something to, at full council, if this goes to full council, to seek assurances at full council from the independent members that they would be willing to go through this process as well. and potentially come back with some sort of monitoring where we can say X number of this group, X number and X independents have, you know, the compliance rate is the wrong word, but we can do that.
Thank you. So, in light of what you've said, I suppose this committee can expect a report at some point that will capture a lot of that for us to consider. We'll move to the then final vote on the recommendations as amended by Councillor Harrison's amendment. So if I just get the wording up. The recommendations are for Standards Committee to discuss the introduction of basic DBS checks for elected members at the time of election, because that's been amended, and to recommend to full council that this process be adopted. For Standards Committee to agree that the Chief Executive, in conjunction with the leader and support from the monitoring officer, to manage the process for failure to complete DBS checks, and if the check did reveal an offence. Yes, Councillor Jays.
If it's at time of election, does that mean no one's going to be checked for 3 years?
Sorry, say that again.
So you said it's at time of election. What about all of us now, the 47 that are currently, or 46?
Yes, I suppose that is a fair point, that there needs to be, in the initial phase, a catch-up opportunity. So, yes, that needs to be noted in that. Councillor Tutt?
I was going to make the same point, that obviously it needs to...
So it's at the time of election and for existing elected members at the point of this recommendation being passed. Any comments on the second recommendation at all? Councillor Harrison?
I think following Councillor Palmer's comment earlier, and he's not the only one in the room, he's not the only one on the council who has a current DBS, whatever it's, yeah, that thing. So something in there that says, and those people who've currently got one, you know, if everyone else has got to have one within a month of this being agreed, I'm making that up, by the way, it might be 6 weeks. And those people who have already got one, they've got the 6 weeks to actually say, here is mine, take a photocopy or whatever. And if you are not prepared to do that, then you're going to have to go through another one. Thanks.
Councillor Palmer?
It's an offence to photocopy a DBS. You have to put the reference number in. Reference number, date of issue and the type.
Yeah.
Yep, thanks.
Thank you.
Okay, so what we're saying is that it will be at the time of election and for all existing elected members at the point of this recommendation being carried, and those who have a passportable DBS check will be asked to provide evidence of that, details of that. Councillor Palmer.
And is that provided to the monitoring officer? Not trying to make any work for you.
Just to check, please.
I think in actual fact I was involved at the point, I think to clarify with Charlotte, I was involved at the point whereby there were issues to be addressed. That was an advisory capacity, is that right? So.
Did you see what you did? The place that I think it would be best for it to go would be Democratic Services. Because, yeah, sorry. The reason being we hold other information about members in Democratic Services, and we would hold that information, and what we would hold is the reference number. That's what we would hold, you know. So, and I think just because that's where we don't want to create an industry, and that's where we hold all the other members. And then when we do it on the termly basis, when we start that, there'll just be a place for it to go within Democratic Services. So it's only if there is an issue that it will go somewhere else.
Okay, Councillor Bonny.
Do you want to have in there a mechanism whereby if you think you need one, something's happened, that you've got the remit to go and do that? I think the answer is probably yes, isn't it?
Agreed.
If something happens mid-term, for some reason, council's alerted to it, it's in the press.
Councillor Palmer.
The only problem is, if you start doing that, you're singling someone out. And that could be a problem. But I can see your logic in that. But...
I can understand the point. Yeah, okay, quickly.
Make a comment. Things in the press won't necessarily appear on a DBS.
Yes. I think we've got an amended recommendation here at this stage, and I think Councillor Harrison's point I tend to agree with. If we can get this over the line, then we can. There's a few more crinkles maybe than we thought, but we can come back to those. And I've already got an assurance, which I hope is noted, that we'll get a report back on this as well that will highlight some of these. So hopefully it can be captured in that. So we have the amended recommendation, and just for clarity again, is the first recommendation has been amended to say that it will be at the point of election, plus all, and for all members who are currently elected at the point that this recommendation is carried, and that those who have passportable DBS checks will need to provide evidence to Democratic Services. Councillor Harrison.
Apologies, Chair, because it popped into my head one of our members who's reasonably seriously ill. That's not a contradiction in terms. That's why I said, within a month, within 6 weeks. I think you've got to say. I think you've got to give a period, because what you just said was.
Okay. Would you like to propose a time frame then into your amendment?
I don't know what members might think is reasonable. I think you've got to give a period.
Okay. Yeah. Would you like to propose one? Put one on the table, and then we'll go from there.
Would 6 weeks be reasonable?
Anybody like to agree or disagree with 6 weeks? Councillor Gibson.
Second, 6 weeks.
Anybody else? Okay, then we'll add in can we get a show of hands for 6 weeks, please? Excellent, thank you very much. So that's added in. Now we will take the final recommendations as amended. I'm not going to go through it again. All those in favour, please. Okay, that is unanimous. Thank you very much, members. That's the end of that item. Now to the moved item 6, member development strategy. Larissa Reid to introduce, please.
I'm very sorry, Chair, but if you look at the papers, I've noticed that although the member development strategy the report that attached to it is the wrong report, and therefore I don't have a report. So with great apologies, I would ask if it was possible to.
We'll defer.
To
we'll defer to the next meeting. Thank you.
Sorry.
Councillor Tutt. Yep.
Yeah, sorry, Chair. I've struggled through this evening with not having had the right papers at the right time.
Yep.
And it's made it rather difficult, as you can imagine. The worst thing I think this evening has been that various members have been talking about what was said at training, what the trainer said, what else said. I was invited for training back in December last year. To date, I haven't had any notification of any training happening, and therefore I haven't had any training.
Okay. I thought it was agreed at the previous meeting it would be opened out. I'm not sure why that didn't happen. However, it was recorded, so we can make sure that there's provision for you to see that training. And yes, I'm very sorry that you weren't given that opportunity. Councillor Palmer.
I was just going to say it is recorded and maybe a copy could be sent.
Yeah, if that could be noted so that we can make that an action for Councillor Tutt, but also anybody else. I think all members perhaps need to be reminded that that's available, because it was open to all members. It's an informative training process, and I'd encourage them all to use that as it's been recorded.
I wasn't upset when I was locked out of the building and I couldn't get into the meeting. It was only due to Larissa that she came down and let me in. But the training thing, from December till now, it's a bit.
Yes, no, I can totally appreciate that. Councillor Bonny?
Yeah, I know we're sort of postponing the training schedule. I did have a look at the dates of the one that we were provided with, and I suppose a bit of a plea is there's quite a lot of planning training that's quite a long way out, and I think we've got quite a few committees of some quite substantial items coming up. Whether they could look at review some of those dates and maybe bring some of that forward. So I'd rather see the planning committee fully trained on things like conditions, design codes, which is a real bugbear. Maybe if we can pull that forwards, that'd be great.
Okay. Hopefully that can be noted for the deferred report as well. Yep. Okay. Was there any, Councillor Palmer?
All I was going to say is the planning training, the standards training I thought was very good. And if it could be shared, it might be a benefit to share with other parish councils.
Yes, and I think that was part of the reason why we went with the option we went with, so that was available, because the only other provision wouldn't have been recorded, and we do want to make sure that's open to parish councils. So yes, that can be captured, just so that we can perhaps also be updated on that at the next standards committee about who might have come forward, express an interest. I think the call would be to go out to people who might wish to access that training in the first instance, and we can go from there. That would be helpful, if that's okay with members. And then we move to item 8, standards hearing arrangements, and I would like Clarissa Reid to introduce the report, please.
Thank you. Just on the previous matter, it is on the agenda to talk about the local council's liaison forum to offer that training to all parishes. So thank you, Chair. This agenda item is comes from a standards hearing held on the 27th of November. Following that, there was a complaint received by myself in relation to the outcome of the hearing and the process undertaken. We have undertaken 2 separate reviews. One was an internal complaint review, and the other one was an external, an independent investigator review, not the independent person. And from those, some recommendations were suggested, and they are that the council should make clear on the website the process for making complaints against councillors, ensuring that there are clear, comprehensive procedure notes for undertaking a hearing. If the monitoring officer is the investigating officer, ensure they are not sitting at the top table with the members and legal, with the panel and legal representative, chief exec, but somewhere where there can be no perception of influence. Provide formal training to members of standards committee in undertaking hearings. That's already happened. Not allowing members to sit on hearings until the training has been fully completed. Again, that's been happening. So the recommendation is to agree the changes to those hearings as set out.
Okay. Do I have a proposer for those recommendations? Councillor Harrison, seconder. Councillor Palmer. Councillor Palmer. Okay, no problem. Go ahead.
I just think 223 under 2.2, 223.
Yeah.
If the monitoring officer is the investigating officer, I don't think you need to put if the monitoring officer is the investigating officer. I think you just put the investigating officer.
Okay.
Shouldn't sit there, because the investigating officer could be another.
That's absolutely fine. I just copied it from the recommendations, but it's a very good point. The investigating officer shouldn't sit.
Yep.
Here. Yeah, that's absolutely fine.
Okay, that's fine. Don't think anyone wished to disagree with that, did they? So that can go. Any other comments from members on those? Councillor Harrison, now is your last opportunity to propose your suggestion.
Yeah. I propose that at the after this committee, and my personal view would be after each and every standards committee, on account of I do believe in the Chinese water torture treatment, water dripping on a stone will eventually make a hole go through it, but that's me. So at the end of this committee meeting, I propose that the chair writes to the relevant minister and asks for a review of the standards process that local government are currently working under. Just leave it at that. Thanks.
Do I have a second of that? Councillor Miller? Did you wish to speak at all, Councillor Miller? No. Anyone wish to speak against that recommendation? Right, let's move to these separately. Let's take the first recommendation, which was proposed by Councillor Harrison, and seconded by Councillor Palmer. All those in favour? And then we move to the second suggestion, which is from Councillor Harrison and seconded by Councillor Miller. All those in favour? Any against? No. Okay, that's the end of that. So I call the meeting to a close at 21:23.
Well done. Well done.